Let's talk about Tiger King. Have you guys heard about this?
I've not heard the latest and greatest on Tiger King.
No, you need to inform us because I don't. All I know, I watched the first season, but I didn't see season 2, and I don't know any new developments that are happening. So
I have not seen season 2 either, but I have been following Joe Exotic on Twitter. I'm assuming someone else runs his Twitter for him since he is actually in jail, in prison. So yeah, so I'm assuming it's someone else that is running it for him. But he has a legal team that is also regularly tweeting about how they're trying to get his sentence reduced and how they're trying to. Now, I think just today they filed a motion for a new trial. So I'll give a little bit of the background. Okay, so if you've watched season 1, you know that there was this whole plot that he got picked up in to have a certain person do a certain thing to Carol Baskin for money. In other words, he wanted to hire someone to kill her. Is the story? So his attorneys still maintain that was a, he wasn't serious about it. There were apparently 2 people that he was convicted of I guess soliciting to murder her, and one of them turned out to be a federal agent, and he apparently there is audio of him offering $10,000 and then to follow her in the mall, in like a parking lot of the mall or something like that, and hit her over the head and be done with it or something. But I think what they're saying is that he wasn't serious about it. He was kind of more being hyperbolic or whatever. And so that shouldn't really be a proper conviction. So I think, I
don't remember. Was the killer, I don't remember from the season, was the killer an actual glowy or was the killer turned? I think he was a glowy, and I remember thinking if you're ever in, I'm not trying to help anyone kill someone, but if you're ever interested, my thought would be, and this is not legal advice, clearly, definitely not. This is like anti-legal advice, but I would just think,
don't listen to it.
Don't listen to anything I'm about to say. Everyone just close your ears. A common sense thing would be if someone says, hey, for $100, I'll kill that person for you. The price is probably too low. I think it was you said 5,000, but even that, I would think offing someone, if they're charging anything less than 10, it's got to be a glowy, right? I mean, wouldn't you think that that's way too cheap for someone to embroil themselves in the potential life sentence exposure type of thing if they're charging you anything under 5 digits? That's just my thought. I don't know. You can't take care of fixing your credit score for under 10,000, and you're gonna fix a problem like getting rid of someone for 5.
So what would you charge?
Well,
what is your going rate, Joe?
My rate is considerably higher, but yeah. No, I'm sorry. I cut you off, Alita.
I was going to say this is the part where I admit that I have seen this term pop up so many times, and I have never asked anyone what it actually means. And I know it's on these kinds of conversations, but I don't actually know what it means. What is a glowy?
It's a federal agent.
Oh, okay.
I'm not sure,
but where does that come from?
Term. Yeah,
I don't know the origin of it, but yeah. I only learned that like a month ago, so I'm not that far ahead of you. Even though if you look at our respective incidents at the moment, it looks like I'm like 9 years ahead of you, but I'm really just a month ahead of you. So, are you in like Czechoslovakia? Your internet is basically saying Eastern Europe. That's what your internet is saying.
It is a part of the world where sometimes internet is great and sometimes internet is not so great. So I'm sorry because I completely froze out during the explanation of what a glowy actually is.
Federal agent.
Okay.
I'll mime it.
So that's just okay. All right. Cool. I guess I can accept that. So
and that I learned that only a month ago. So I'm not ahead of you.
Got it.
I feel embarrassed.
Got it. All right. So So I think it's not disputed that this person was a federal agent.
Okay.
So I don't think anyone is fighting that. The question is, to what extent was this like a legitimate legitimate sort of God, what's the word for it? Where they have agents that come in, a sting operation. To what extent was this a legitimate sting operation, and to what extent was this an entrapment kind of situation?
Right.
Yep.
Now, entrapment
again.
entrapment is a tough defense.
Yes, it is.
In general, it's a very, very tough defense. First of all, you cannot even rely on entrapment if you have a predilection toward it.
Yeah, that's you're done. If you have a predilection, you're done.
And then, in other words, if someone is proven to have a predilection towards a particular crime, in that case, and they say, well, you trapped me into doing it, they say that your predilection wipes away any entrapment, and basically the government could do whatever they want to entrap you into a crime. Right. And your defense of entrapment is something that you can't even offer before the jury.
Yeah.
So so and considering how many times this guy said he wanted her dead, that's a tough road. It's a tough road.
Yeah, no, I definitely agree. And I think that the Whitmer case, the Whitmer kidnapping plot case, I think that one seems to be a stronger case for entrapment.
Yes.
Rather than I mean, because they had multiple instances where they were like, we're not going to do that. We're not going to do that. We're not going to do anything like that. And then the person that was pushing for it was actually an informant. So here it is a little bit more difficult, I think, to say that there would be an entrapment situation here because of what has been readily apparent on Netflix on the first season, right? Granted, there could have been quite a bit of editing in there that would have made things look a different way. So I'm very curious to see, because I'm very curious to see the motion that they filed today. It should be showing up. I mean, it'll probably show up tomorrow on Pacer, but it's supposed to be a very, very hefty motion. But that would be crazy if they actually do end up getting a new trial to see if they can free Joe Exotic from prison, because otherwise their most recent attempt. So he was convicted of this murder for hire situation, and then he was sentenced to 22 years. And then they appealed that sentencing because they said that it was improper the way that they sentenced him, because they sentenced him for two separate crimes, even though the two were, I guess he talked to two different people about Carol Baskin in both situations. And so they said that because it was for the same end, that the sentencing shouldn't have been expanded. It should have just counted as one. They should have overlapped.
That's kind of that's sort of the typical rule, although it can be heavily modified in terms of whether sentences should be served consecutively, one on top of each other, or concurrently at the same time. Yeah. So the typical rule, and again, you have to be very careful with this, is if you serve them concurrently when it's part of what you call the same criminal transaction. And that is basically when things are closely related in time and purpose, for lack of a better description. So you're doing things as part of a contemporaneous thing. Like, I don't know, I'll give you an example. You go to rob the bank, you have a getaway driver. So there's a whole number of felonies that are being committed here by a whole number of people probably, but they're all part of the same common criminal transaction, to use the proper term. So that's what you're looking for. So he's arguing that because these were closely related in purpose, they go into the same end, therefore concurrently would be appropriate, which is the typical rule, but has been modified by statute in some cases. Perhaps most notably, for example, in Colorado recently with that whole trucker case where he got 110 years and then the governor had to reduce it to 10. Right. Those sentences stacked on top of each other, even though it's all related to the same thing. I mean, how could it not be? It's all related to one vehicle fatality, but Colorado modified the rule, which caused that excessive sentence. So there's a counterexample for you.
Yeah, yeah.
You would think that.
Yeah,
So if
no,
he
that's a great explanation.
I don't recall. Did he talk to two different people about killing her? Because that sort of mitigates, that shows predilection, right? I mean, and here's the other thing. And if you want to take the side of the government, which I know no one ever wants to take, that's a very unpopular side to take. But if you want to take the side of the government, so you're trying to figure out, does he really have a predilection or not? So his defense would be, all those times that I was saying I want her dead, I was speaking euphemistically, I was speaking in exaggerated tones. Kurt has said he wants Good Logic dead 100 times. That doesn't mean
I don't
that
think
he
it's
would
reached 100 yet. I think you're giving me too much credit.
But that doesn't mean that he has a predilection towards killing me. But one would think that only someone who has this predilection would actually give someone money. And you could, in other words, Kurt couldn't be entrapped into killing me unless he's really serious about it, which means that he's really serious about it. So you had the predilection. So that's sort of, I think that's why the predilection mitigates against the defense of entrapment, because we're saying, look, you're saying you were joking, but if you were joking, you wouldn't be tendering money to get it done, so you wouldn't be able to be entrapped. And yeah, that's sort of so. And so if there's two different directions he's going to try to attain this objective, again, it's hard to say he doesn't have a predilection towards getting her killed, and that there was seriousness behind it.
Yeah, so this doesn't look like it. The Whitmer case looks closer to it. It was enough at least to get my attention, to raise the question in my mind. So that was what you normally don't see. People yell entrapment all the time. Most of the time, like, no. But it was enough for Whitmer to get my attention.
There's also a concept that she doesn't hear me, does she? She doesn't hear me. You do. Okay. So I'm gonna share with you that
I hear you. There's just a delay. I'm sorry.
That's okay. That's okay. So there's my first year of law school, when we had to do a legal brief, I was taking a legal writing course, and the topic that we happened to cover, which is why I know a little bit something about this, is outrageous government conduct. Is a concept that was developed in a case, I think in the 70s. I don't remember the name of the case because I'm going back to literally first year law school, but basically that even though the general rule is what we've been stating, that if someone has a predilection towards a crime, that you cannot rely on entrapment. That's your standard entrapment defense. But the Supreme Court opened up a concept that when there's outrageous government misconduct towards entrapment, that even if someone has a predilection toward a crime, conceptually, there could be cases where that predilection would not stop them from raising the defense of entrapment. Meaning, let's say someone really has, we consider it's definitive. We consider it definitely proven that someone has a predilection toward a crime if they've committed a crime in the past. So if someone has been convicted of being a drug dealer, and then they get out of jail and they're living a healthy, typical law-abiding citizen lifestyle, and they get entrapped into dealing drugs again. So we would say, well, you have a predilection towards this because you've done this crime in the past. But in a case where there's outrageous government misconduct, for example, you have 7 different agents coming in there and they're threatening you, saying, hey, if you don't join us in committing this crime, we know that you're comfortable dealing drugs. You don't join us in committing this crime, we're going to cut off your fingers or kill your wife or something like that. And they bring you into this ring. That would be considered something like outrageous government misconduct, where it's not his predilection that's driving him towards doing it. And even though he has a predilection, you could rely on the defense of entrapment. There is a concept like that was raised by the Supreme Court. I think it was 1975. But so in theory, with respect to the Whitmer case, where you have a ring of 12 people and 8 of them are glow in the dark, that seems really outrageous, especially some of them are like the ringleaders and they're setting up the whole plan in motion. Even if some of the defendants had a predilection and were genuinely sincere about trying to cause harm to Governor Whitmer, it's crazy when a significant majority of the people involved in the ring are all federal agents.
Yeah.
And even if they had a predilection, in theory, they still could rely on defensive entrapment based on the outrageous government misconduct concept. But yeah, I've been rambling for a while, so I just wanted to share that concept with you guys.
Yeah. So and relatedly, in the Joe Exotic situation, what it sounds like from the statements that I've seen kind of leading up to them filing their motion for new trials, they're talking about how there's been so much government activity, so much government misconduct by the FBI that's kind of, it's similar to what they're alleging in that situation. So it'll be really interesting to read that motion when it does come out. I don't know if it's already been filed now that it's, it's the day of, but I would assume that by the end of the day, it'll have been filed. But yeah, so in that case, what I was going to say earlier is that they were trying to get his sentence reduced because of the fact that they sentenced him to 22 years. And so apparently the appeals court said, well, okay, the bracket that you assigned him into was 22 to 27 years. That's actually improper because of the fact that, these two claims, these two charges should be overlapping in their sentencing, because they have the same end that they are trying to achieve. And so that the Court of Appeals remanded it remanded it previously. And then last week, the trial court looked at, and they did a resentencing of it. And they were like, all right, so now the max, it should be just under 22 years, between 17 and a half and 20, just under 22. And so the court was like, okay, we'll resentence you to 21 years. So basically they were like, they got him a year is what they did. But so people are pretty pissed. The people that are in the Joe Exotic, the free Joe Exotic camp here. But anyhow, but yeah, so for their next attempt is they're going to try to get this new trial, and with those similar sort of arguments having to do with the FBI's over involvement in the situation, supposedly.